Okay. And the next case is State versus Matthew Apperson. And Ms. Kohler, I'm assuming 5 minutes?
5 minutes, Your Honor, yes.
All right, you may proceed.
May it please the court, my name is Pam Kohler. I represent the appellant in this case. The state is appealing from an order, well, actually an order granting rehearing on an amended motion for post-conviction relief on 2 grounds. I primarily intend on addressing the first ground rather than the second ground. The second ground that I'm not going to address, get it straight, is that the trial court found that trial counsel's well-reasoned and tactically sound strategy was to not obtain a definitive ruling.
And now let's let Pinnell try to work through that one.
Okay, so I wasn't going to address that claim. So I'm going to focus on the first claim.
It just seems to me that the critical issue in this case is that there is an argument that you're making is that there's some difference between the language engaged in criminal activity and the language otherwise engaged in criminal activity.
Correct.
You know,
well,
why don't you explain that to me, because I can tell you that I can't see any difference. I mean, I think if you just went to somebody on the street and gave them those 2 phrases, they couldn't tell you what the difference was between those 2 phrases. So why don't you explain the difference for me?
What I first want to do is, obviously the issue here is whether trial counsel was ineffective, not whether this was a proper that sort of thing. I mean,
but you got a case that says that this language was fundamental error.
The previous language, it was modified after Novak, specifically citing the Novak.
But here's the modification.
Otherwise engaged.
Right.
I understand.
So if there's no effective difference.
I would disagree, Your Honor.
Well, and I'm willing to listen to what you have to say.
Sure.
But to me, that's what the issue is. Is there a fundamental difference between those 2 phrases? Because if there isn't, then I think you're back to a fundamental error.
Well, to begin with, I mean, this was raised on direct appeal as fundamental error. But obviously we're not here, but that's part of the problem. Another thing is, this is the way it was modified. This is directed in the jury instructions is to read in all cases. So the issue is how trial counsel could be ineffective.
Well, that might be the problem. First of all, those jury instructions aren't, they're not the 10 Commandments.
Right, but this has remained. I mean, the most recent iteration of this jury instruction still requires the court to read this in all cases.
Between those
sure.
2 phrases.
What happens is the jury is first told about the elements of the offense, and then they're told that they're justified in using this deadly force if they reasonably believe, and all that sort of thing. So they're basically told about the offenses that he's charged with, and then they go only if he reasonably believed that force was required and that sort of thing. And then they go through and that he's justified, that he had no duty to retreat and so forth. And so it's not until afterwards, so they already know what the defendant's been charged with, and that it is a valid defense if he reasonably believed that he had to use force to counter force. But here, they don't talk about the duty to retreat if he was not otherwise engaged until after they've already talked about the offenses. So it's got to refer to something.
But you're not supposed to be talking about that at all unless he's charged with
yes, you are. I disagree, Your Honor. I mean, that's exactly what this case, I mean, the statute, I mean, everything has been,
Counsel,
I mean, it's been 6 years.
I appreciate that as well, but I have the same question as Judge Cohen. I appreciate that it says that you're supposed to do this, but what value did that instruction have in this case?
Because
it didn't say that.
I mean, we include things in jury instructions that aren't necessarily applicable to that case, but it's in order to explain the entire area of that law, you include it so the jury understands what the law is. I mean, there's been case law since then.
Even when there is no otherwise
yes,
offense.
You're required to. I mean,
so
if you look at the jury instructions.
You're telling us that the jury instruction should not address the evidence that comes in at the particular trial.
Well, that's not what I'm saying. What I'm saying is sometimes we include portions of a jury instruction of the law that may not explicitly are involved in this case, but it is the law of Florida in that case of self-defense.
You've got a case that says unless he's charged with a separate crime, it is fundamental error to give an instruction that talks about the commission of engaged in criminal activity.
And
Okay,
since
so-
that case,
So that's fundamental error. You shouldn't be talking about this whole concept of engaging in criminal activity unless it's a separate criminal offense, period. But yet here, we're going to do the same thing. We're going to
And-
talk about the being engaged in criminal activity.
Yes.
Even though it
Yes.
had been decided that it was
Yes,
fundamental.
and in fact,
error.
that's what the current standard jury instruction requires you to do. Absolutely. And so my point is, how is trial counsel supposed to know this if the Florida Supreme Court is telling him that this must be read in all
I'll
cases?
tell you how he's supposed to know it. He reads the case that says it's
And he said he
fundamental
did.
error.
He did read the case.
Right, and he didn't follow it.
Well, I disagree, because it had been modified after Novak. It explicitly cites to Novak
All right.
in that,
And I'm
and that this is
asking-
how we're changing it.
And again, I'm asking you to tell me, all right, it was modified, they added a word. How does that modification change the concept? I don't understand the difference between engaged in criminal activity and the phrase otherwise engaged in criminal activity. Tell me the difference between those two phrases.
Because otherwise engaged, you're obviously referring to something other than the crimes for what he's been charged with. I mean, why include otherwise? That's obviously you're talking about something other than the crimes for which he's been charged.
And that wasn't an issue in this case.
No. And exactly, it was never argued, never ever argued that there was any other criminal activity, that there was any other, that he was in a place he's right to
It
be.
wasn't argued because there was no facts to address
Correct,
that.
absolutely. And I mean, there's been case law since this by the Fourth DCA who issued Novak, where they found that they argued about the jury instruction, and the court said there's no problem because it was clear that the defendant had a right to be in the place he was at, which I did not cite to, and I apologize for that.
Oh, no, then you can't argue
I
it
know,
here.
I know, but
And you know better than
well,
that.
I know, and the point is that there's been no case law since that modification that has found that that was reversible error, even reversible error, that it was deficient in any way, shape, or form in the 6 years since that was modified, since that trial. So I don't understand, this is the only court that, in this case, that has found that to be potentially confusing of any court that has ever had to address this issue in the last 6
What it
years.
does is it eliminates the defense in the case.
Absolutely, it does not negate the defense. Absolutely, I disagree.
All right, it's easy for you to say.
Well, and the other courts, I mean, it's just, there's no court that's ever found that it did negate the defense. That's to say, I definitely argued that in my brief. There's been no court that's found that negated the defense. In fact, just the opposite. So because there was no evidence of that, it was never argued, it's the law of Florida, and they're basically told that, you only have the duty to retreat in these other situations, and in this case, it did actually apply as far as being the initial aggressor. It did not negate the defense at all. And there's nothing for trial counsel to have known. Even if you read Novak, you also would see, the Florida Supreme Court approved the new jury instruction with the modification, and it says it must be read in all cases.
They approved the first jury instruction, too.
Right, which follows the statute. That's the thing, it follows the statute exactly. And then so they put the otherwise engaged because of Novak, and then they've actually have eliminated the citation to Novak since then, and just have that last part, and now basically they have it in 2 brackets, and you still are required to read that part, not otherwise engaged, in all cases, if you're going under the standard subsection as far as the stand your ground and duty to retreat stuff does. So, I mean, honestly, even if he asks for this, if he gets a new trial and he asks the court to remove that part in his jury instructions, under the law, the way it is right now, the judge could still say no. It says, shall read in all cases, and it basically says that he's supposed to read this.
If a trial judge wants to do that, we can go through this process over and over and over again.
Again, that would be the first court you would be the first court to have ever found that to be, fundamental error.
Oh, we love being.
I'm sorry.
Well, and the point is, what is there out for counsel to know that he should have done this? He thought it was no big issue because that was not an issue. There's never argument about that, no facts about that.
Counsel, can you address Martinez and McCullough and the line of cases on the forcible felony and why they shouldn't apply in this case, other than just the fact that we have changed the jury instruction to have the word otherwise? Why-
Well,
Go
the
ahead.
forcible felony thing, it got more into a circular argument as far as, if they didn't make it clear. And again, the fact that it was modified, that counsel should have known this, because once it's modified and you're told, do not include this part of the instruction anymore unless it's specifically applicable, then obviously counsel, is ineffective, is deficient if he fails to do so. In this case, there's nothing to indicate that that should have been removed. There's no case law to support this even today, that language should be removed in this type of trial, even where there's no question that the defendant was in a place he had a right to be, and there's no question that he was not otherwise engaged in unlawful activity. So how is counsel supposed to know
It's
that?
true to me that we discuss things, that are completely irrelevant, that we're going to give jury instructions on things that then they should ignore.
And,
What a risky way to conduct a trial.
But I think it's clear the jury understood it, because they only asked about if you were the initial aggressor and the duty to retreat, and that's totally,
But
that's...
isn't that, just using that word aggressor, isn't that implicating that he may have been doing something to instigate?
Correct, and that there was evidence of that.
That could be a red herring or lead the jury down the path of he was committing or could have been committing.
No. The initial aggressor language is totally
That's
different.
the only word that they use that implicates this jury instruction.
Right, because they had received the initial aggressor language, which talks about, because it's always been the case law, it's always been the case in self-defense, that if you start a fight, you can't complain when you have to use, deadly force.
So the jury is given a word that can argue, I'm sure Mr. Pinnell would argue, cause the jury to go back and look and try and ascertain whether or not he was engaged in another offense, even though you're saying that counsel for both sides never alluded to that, even though the prosecutor did argue to the jury, had a chance to turn down another road.
Absolutely.
Had a chance to disengage.
Absolutely, which has nothing to do with self-defense. Self-defense begins when deadly force is, or imminent use of deadly force is about to be used against you. It was not until he claims that he actually saw the victim point a gun at him. That's when we're talking about the deadly force and the whole justifiable use and all that kind of stuff. What we're talking about is what happened before then. This is whether or not you're the initial aggressor. That has nothing to do with where you committing an offense. We're not saying you have to commit an offense to be considered the initial aggressor. The initial aggressor is just someone who starts a fight, or basically in this case, he got behind the victim's car, he pulled in behind him, he was screaming, calling him names, basically saying, I'm going to kill you, all that kind of stuff. They pull out, he's right behind the victim, pulls up next to the victim and shoots through his closed tinted window.
I'm going to kill you. Isn't that an assault?
In a vehicle, when you're how far apart, and there's no gun in your hand,
With a 3,000-pound vehicle going down Lake Mary Boulevard at 40 miles an hour? Is that an assault?
well, that's not where the purported threats were made. It was when they were at the U-turn, because the victim's right passenger side was all the way up. He had it down a little bit, so I guess when they were in the U-turn, they were able to exchange words. So that's when it would have occurred. He turned, then the victim pulled out to go the other way on Lake Mary Boulevard, and then the defendant followed him behind and then pulled up next to him, claiming he wanted to get around him, and that's when he claims he saw the victim point, so he shot at
Didn't
the victim.
have a car full of guns?
Who, the victim? I don't really remember if they found guns or where guns had been. I think about one or two, maybe.
And isn't this a victim known to be armed?
Absolutely.
Right.
Yep. But again, the point is self-defense, your right to use self-defense begins when you are in imminent danger. It's not when just because, you might have had an argument before. It happens when you're in imminent danger of deadly force. And according to him, it wasn't until he had pulled up next to the victim and he claimed he could see through a heavily tinted window the victim pull his gun, and that's when he shot. That's what we're focused on. That's what the crime's focused on. What happened before has to do with initial aggressor. That does nothing to do with justifiable use of deadly force, except to the extent that you have a duty to retreat if you are the initial aggressor, because you are not allowed to start a fight and then use deadly force if you could have gotten away.
Well, Novak, I mean, that's pretty much the same scenario as in Novak.
Well, Novak, they mostly, to be honest, they mostly were concerned about, in Novak, the jury instruction on who had to prove beyond a reasonable doubt the defense of self-defense. And that's like 90% of the opinion is talking about that. And then they say, oh, and by the way, they also don't like this too, and we agree that you shouldn't do that on your next trial. So that would disagree. I'm going to reserve the remainder for rebuttal. Thank you.
You don't have any time to reserve. Oh, I'm
Oh,
sorry.
I'm
Yes,
out.
you do. Yeah,
Never
you do.
mind then.
4:30.
Yeah.
I guess there was a
Pennell.
4-minute and 30-second penalty for something.
May it please the court. My name is William Pennell, and I represent the appellee Matthew Apperson.
How do you spell that last name?
So, the court is correct that the victim in this case, George Zimmerman, was found to be in possession of 2 guns. I think and he obviously is well known. The most important fact is that Mr. Apperson was claiming self-defense as a defense to all 3 charged offenses.
Right. Is there any case law that has interpreted the change in the jury instruction from criminal activity to otherwise engaged in criminal activity in terms of the legitimacy of the jury instruction?
Not that I'm aware of, Your Honor.
From any other states, I noticed the state of Texas has a very similar statute. Are you aware of any other states?
I am not aware of it. It's our position that the trial court got it right when the court said that there's no material difference between the instruction in Novak and the instruction given in this case. We have a jury of lay people. They're not lawyers. They're not wordsmiths. Otherwise, certainly doesn't tell them it has to be an offense that's not charged, or that a defense that Mr. Apperson is not claiming self-defense to. In addition to the self-defense instruction on page 841 of the trial, the jury is instructed to consider each charge separately. So, let's say when they're considering the attempted murder charge, and they may conclude that because Mr. Apperson was also committing aggravated assault, that he was engaged in otherwise engaged in criminal activity and had a duty to retreat, and that results in a directed verdict against him on the self-defense. So if they apply all the instructions and they consider them individually, every single time they consider an individual charge, there's other criminal activity that negates the defense. Now, if you look at the prosecutor's argument, if this word otherwise is so important, it's so important and it makes it different than Novak, then why doesn't the prosecutor use it when he's making the argument about what the jury instructions say? If you look at page 814 of the transcript, the prosecutor says, the second exception is if you yourself are committing a crime and then you claim self-defense, you have a duty to retreat. It doesn't say otherwise. It doesn't say a crime not charged. It doesn't say a crime that you're not claiming self-defense. So this otherwise word is not important because the prosecutor himself didn't use it. The trial lawyer in this case testified he knew about Novak, read it. He concluded that he did not, he drafted the instructions himself, that's undisputed, and he did not omit this portion or modify it of the instruction because he said there wasn't an issue of criminal activity and other criminal activity in this case. The problem with that is that's a misunderstanding of the law. That's the exact case when the instruction should not be given.
It completely misses the point.
Right.
Counsel, what do you say to the state's argument that, these are the standard, they're told to give all of them? What do you say to that?
Well, every standard instruction that was ever promulgated by the Florida Supreme Court, and including this one in 2016, has language that says, quote, in authorizing the publication and use of these instructions, quote, we express no opinion on their correctness and remind all interested parties that this authorization forecloses neither requesting additional or alternative instructions nor contesting the legal correctness of the instructions. So they're not saying they're correct. And they're not absolving the trial judge, the state, or certainly the defense lawyer from applying law. So let's assume today,
In fact, haven't they gotten out of the business of doing?
they have, in 2020, they appointed a committee and said they're no longer going to be involved for this reason. They said that trial judges and lawyers were misunderstanding that they were saying that these instructions were correct when they were just saying this is a starting point.
Mr. Pennell, could you provide some clarification for me? So in the hearing, the first hearing that was held, Mr. LaFay was questioned, and there's been talk about, I guess somebody mentioned the word non-issue here today. However, there were questions and answers that I'm wondering whether or not that was so clear. The question was why you chose not to rely on Novak and asked that those portions of the instruction be stricken. The answer was, I didn't think of it. So, and then, okay, had you thought about it, would you have excised those portions of the instruction or sought to keep them from being read to the jury? Absolutely. So, obviously, we know he didn't get them excised, but this goes, I think, further. He didn't even ask to have them excised.
Correct.
So, was he aware? Was trial counsel aware of Novak truly? Or is this answer inconsistent with the previous answer of it was a non-issue?
He says he was aware of it. He had read it before the trial. There's been no finding that that was not credible, or and I don't think we have any reason to disbelieve him.
Well, maybe the issue is the difference between being aware of something and understanding something.
Sure. And the case law is clear. If you misunderstand something, a misunderstanding of law, it can't be a legitimate strategic reason or a legitimate basis for not doing something. And he didn't just not object. He drafted the instructions and gave them to the judge to read. That's undisputed in this case. And I think that's important. I think the courts have made a distinction between affirmatively requesting instructions as opposed to not objecting. That may be different, so I think that makes it more evidence of deficient performance. Additionally, the fact that he objects to the state's argument when the state argues that one of the exceptions is you're engaged in unlawful activity suggests that he was deficient by allowing that instruction to be there in the first place. If he's objecting to the state arguing it, why did he allow that instruction to go before the jury? Because now the state's relying on the instruction. So I don't think there's any real argument that he was deficient because there's no distinction, no material distinction between Novak, the instruction in Novak, and the instruction in this case.
And do you think in this case that instruction eviscerated the defense?
I do, Your Honor. I think that if the jury believes that because he was engaged in multiple crimes, and he's self-defense by its definition is an admission of the conduct and then a defense. So if they believe that he was engaged in another crime, then that's a directed verdict, like they say in Martinez and the line of cases with the forcible felony. There's no real distinction between the forcible felony exception and the instruction given here as to how it negates the defense. And to answer Judge Nardella's question, for that reason, McCullough and the line of ineffective assistance cases from this court, the Sloss case, McCullough, where they found ineffective assistance for consenting to the forcible felony instruction, apply equally to this case. And that's what the trial judge in this case found, that McCullough supported granting the motion. The state's argument that the state never argued that there was a duty to treat, I think Judge Wallace pointed out that there was certainly arguments in the beginning of the closing argument that went to that. But more importantly, the prosecutor explicitly said, quote, and this is page 914 of the record, quote, no duty to retreat. Mr. LaFay made that argument, well, he is wrong. Quote, the second exception is if you yourself are committing a crime and then you claim a self-defense, you have a duty to retreat. Then he says, so look at the jury instructions real close and you will see that there are two exceptions. So the state says they didn't argue it, but they did. They did argue it. The The prosecutor told the jury to look at the jury instructions closely to look for this exception. Both at the evidentiary hearing and in the briefs in this case, the state keeps arguing that they weren't applying that to Mr. Apperson, that this was some general discussion of the law. This isn't a seminar on self-defense law. This is closing argument in an attempted murder case. He's telling the
Now,
jury.
Mr. Pennell, if the prosecutor doesn't make that argument, are we here?
I think we're still here, but I think it's more evidence of prejudice. I mean, and
Yeah, let's talk about that second prong, prejudice.
Sure.
We've been over the first prong, but the second prong, and I read the trial court's order not necessarily as saying, we think the jury instruction by itself is misleading, but we think, in the line of McCall and Martinez, just having that jury instruction when it's a non-issue is confusing to the jury.
well, I think
If this panel were to agree with that line of reasoning, how do we look at the prejudice prong?
I think you look at the prejudice prong. Number one, the instructions confusing and misleading, and then number two, the prosecutor took advantage of it and told the jury in the beginning of the argument that Mr. Apperson should have pulled off, should have stopped, should have made a U-turn, and then specifically told the jury, this is an exception. If you're committing a crime, then you have a duty to retreat. And look at the jury instruction. So now, not only do we have a confusing instruction, we have a prosecutor telling the jury to rely on that instruction to find that Mr. Apperson has a duty to retreat. If they believe he has a duty to retreat, game over. He's guilty whether they believe he was justified or had a reasonable fear of injury or death, or serious bodily injury or death. And the curative instruction, or I don't want to call it a curative instruction because it's not, the judge just says, after Mr. Lafay objects to the mischaracterization of the law, the judge at page 814 says, ladies and gentlemen, I will be reading the instructions to you. The copy of the instructions I will read. We will be going back to the jury room with you. What I read in those instructions you will see are the law. So the judge is now doubling down about the incorrect instruction, because she doesn't say that argument's wrong, we're going to change the instruction. She says, what I read to you is going to be the law, and then she reads the improper instruction. So the prosecutor's improper argument is not stopped, it's reinforced.
Before you sit down, it's just, it wouldn't be as much fun if we didn't talk about a trial court's finding that something was a reasonable strategic decision and then it constituted ineffective assistance of counsel. Let me hear you defend that one.
So I agree that you cannot find, as a general rule, you cannot find that it's, if it's a reasonably strategic decision, that it's ineffective. I think the judge is wrong that it was a reasonable decision under the facts of this case, but for the reasons I just said. The judge's response reinforced the error. So the Rodriguez case from this court says that a defense lawyer has an obligation to object and get a curative instruction, and that curative instruction should inform the jury that the state misrepresented the law and make it clear. He didn't get that. He should have asked for that and got a more definitive ruling. So, and his explanation, well, I wasn't sure how she was.
It seems very difficult to say that not getting a definitive ruling, it constitutes ineffective assistance of counsel because there was prejudice to the defendant by not getting that more definitive ruling. I mean, goodness, I can't. We would have that issue raised in almost every single case that goes to trial.
Well, certainly it's fact specific, Your Honor. Like, I think here where the prosecutor is misrepresenting the law and the law has been misrepresented in the jury instruction, you need more than, I'm going to read you the law, which is wrong. And he didn't ask for that. And he said, well, I was afraid she was going to overrule it, my objection. And the case law from this court and the 11th Circuit and Strickland itself says we have to assume that the judge would have made the correct decision of law. And the correct decision of law would have been to instruct the jury that is a misstatement of the law and to instruct the jury to disregard it. That's not what happened. But even if the court concludes that by itself, the failure to get a more specific ruling or more specific curative instruction is not ineffective assistance, the provision of the instruction was deficient performance. It prejudiced Mr. Apperson, and the argument of the prosecutor further exacerbated the prejudice. So we don't have to get to that to affirm here. We just have to say that.
I trust that you hope that.
Right. I mean, so I think that we have a confusing instruction that the prosecutor took advantage of, and we did not get a curative instruction that took away the prejudice. So we have both deficient performance and prejudice, and for that reason, I'd ask the court to affirm the decision of the trial judge.
And Ms. Kohler, I apologize for inadvertently raising your heart rate, telling you did not have 4 minutes and 30 seconds, so you may
That's okay, Your
proceed.
Honor. I guess just to re-argue the fact that, I mean, basically, the trial attorney is relying on the standard instruction, and even post-Novak, the 3.6F still says, read in all cases. It's never been found deficient or inaccurate. In fact, it did not negate his defense because.
About the first time that, these issues come before a court.
Understood.
Yeah.
But,
Counsel, would you find, can a jury instruction be both accurate, but if placed into a case where it's not an issue, confusing?
well, then you have to find basically a misjudge, or what's the language of law? I mean, basically, it has to be pretty extreme. I mean, as long as it's a correct statement of the law, it was never relied on, as far as it was never argued to the jury that either of those prongs applied here, as far as a duty to retreat. The only one that was.
I don't think that the language that Mr. Pennell cited, where the prosecutor says to the jury, look closely at this sucker.
Well, he says two exceptions. He doesn't go straight to, Mr. Pennell jumped over one. He first says, the first exception is if you are the aggressor, you have a duty to retreat. And then he says the second exception is if you you yourself are committing a crime. And, I mean, obviously the state there was evidence to support the aggressor part, but there was no evidence to support the other. And they were given the corrected jury instruction that said otherwise engaged, which why put in the word unless you're talking about something other than the crimes for which they are being charged and for which they're before
They might
there.
have tried to do that. Whether they did that or not is another story.
That's what they did back, like the year after Novak was issued, and it's been that way since then. So, I mean, how is counsel supposed to know if all the courts since then have not so found that, how is he wrong?
You can't just say, all right, well, it was a standard instruction, so I'm not going to challenge it and say, well, that's okay. I mean, is that where we're at? Is that what your
Well,
argument is?
the point is that it's even assuming this, I mean, presumably this has been challenged since then, and yet there's been nothing to
Well, I don't know
hold
that.
this way. I mean,
I haven't seen it.
yeah, well, I just know that this has never been, I mean, this is still the law in Florida, and this is still says read in all cases in this situation, and basically I would submit that because it was never argued that he had committed any other, engaged in other offenses, and that he was in a place he had a right to be, that there was no, it did not get rid of his defense at all. And in line with other case law. So anyway, we would rely on our brief on the rest, and we would ask that you reverse and remand for reinstatement of the conviction and sentence. Thank you.
Thank you, counsel, for your arguments, and we're in recess.
All right, and then we'll go ahead and